Hello neighbor, I'm Robert Burns and welcome to the 5th installment of the Stanford Victims Trial against the Louisiana Office of Financial Institutions, or OFI for short. And I'm going to do things a little bit differently today than I've done on past sessions. I'm going to give a quick, just the nuts and bolts of what transpired, and then I want to focus in on one specific moment in the trial because it's my belief that this may have been a pivotal moment in this trial, and particularly the effectiveness of Mr. Phil Price. Now, as many of you will remember, I stated that I didn't particularly care for his unique style of questioning, but I can tell you that I believe he landed a very solid blow on Friday, and I'm very candid that I think the OFI did not provide an adequate enough counter blow. Now, they have plenty of time to undo what I think was a very inadequate response. And we'll get into the specifics in just a moment. But basically what transpired, I'm giving a 36,000 foot view, and then we'll drill down. And I'm going to try to avoid all duplicative type material that's been covered in prior lessons, because there was plenty of it. But for about the first hour to hour and 15 minutes, outside of the presence of the jury, the two attorneys argued over whether or not a DOBAR hearing would be needed for two expert witnesses that the OFI wishes to call. One of those two experts is an Alabama securities regulator who has attended the trial in its entirety, and the other is a lady named Miss Carol. Miss Carol Van something, and I'm sorry I didn't catch the totality of her name, and I'm not sure what her role is. All I know is Mr. Price had previously retained her as an expert, and as Mr. Dennis pointed out, he's one of the three defense attorneys. He said obviously she didn't point the finger of blame at OFI, and now we want her as an expert witness, and all of a sudden you got a real issue with it. But Mr. Dennis drove home the point that Mr. Price had not followed the proper procedure for seeking a DOBAR hearing. That should have been done weeks, if not even a solid month ago. The judge has delayed making any ruling on that, and my recollection, I'm pretty sure I'm right on that, he said he will deal with it at the point that OFI may seek to call either of those two individuals as expert witnesses. Now, one of them, Ms. Carroll, she has made it clear she's not coming. She challenges the jurisdiction of the court to subpoena her, which is probably a dead giveaway that she too is from out of state. But they have conducted a video deposition of her, and it's segments of that, very similarly to Ms. Allen, who was the boots on the ground deponent for OFI, who also had video testimony. Phelps Dunbar wants that in. So, in a nutshell, that consumed an hour and 15 minutes. The jury's not present for any of it. When we left off what would have been last Thursday, Mr. Price had just finished questioning Mr. Seymour. Mr. Seymour was put on the stand for the OFI, and contrary to my indication to you that I thought they would be posing cross-examination questions, it wasn't long before Mr. Price stood up literally on about the second or third question, and he objected while Mr. Seymour was testifying. And Miss Eddy, and I apologize for having mispronounced her name on the last segment that you may have seen beneath the caption. I apologize for that, but I got it right this time. Miss Eddy said, look, this is my witness. He is on direct. He is not on cross. And so she proceeded to question him. Now, we'll come back to that because I want to skip to Mr. Price then engaging in the cross-examination of Mr. Seymour. And what I've done, because I do believe that this has been the most impactful section of the trial. And so I'm drilling down deep on this one aspect because it's my personal belief that it resonated with the jury. That's my belief. I also believe it was not adequately handled by OFI to thwart the perception that I'm about to give you. Now, Mr. Price had referenced very briefly in the prior episode. I had said that, okay, he had kind of gently nudged the topic about, okay, you had said that the state member banks cannot invest in these Stanford International Bank CDs, but yet it was okay for my class members. On Friday, Mr. Price really went for the jugular on that, and I do mean the jugular. And what we're talking about is a memo. Remember last time I said I thought it was dated April 15th, but don't hold me to that date. Well, since it was put back up today, I could tell you that it was actually April the 3rd of 2004. April the 3rd of 2004, and what I am opting to do for this feature is I am making a replica of that memo, and it will be in the form of a JPEG immediately beneath the video, because I feel like this is so important, what happened here, that it's important to get not just mental work, not just voice, but also see a replica of what this memo said. And what the memo said was that we do not, this is being sent out to all state member banks that OFI regulates in Louisiana, and it said we would view the purchase of Stanford International Bank CDs to be, quote, unsafe and unsound banking practice, okay? And it was at that point, and you need to realize Mr. Price has a very deep bass voice, and it's a little scratchy, so he's going to be heard, okay, especially when he wants to make it a point. And basically what he said on this with Mr. Seymour on the stand was, so it was okay to let my class members, let them go out to be fed out to the wolves while you simultaneously protected your state member banks. And I'm pausing because, you know, at some point in the trial, you'll see something that you believe is, and I do believe it, was a very impactful statement, okay? And I want to repeat it again. He said, so you had no problem throwing my class members to the wolves on these Stanford International Bank CDs while you protected your state member banks, saying it was unsafe and unsound banking practice. Now, none of the defense attorneys are accountants or regulators, so I can understand where they would have some difficulty posing some proper questions of Mr. Seymour to try to thwart. I mean, I have a mental image in my mind of these elderly folk being just tossed out to a pack of wolves and being allowed to be attacked, but the much larger state member banks that had far more in assets being protected, you know, by the same regulator. And in the Thursday feature, I had stated how I would have answered the question had I been on the stand. Now that was when Mr. Price was basically playing softball with this whole issue. He played anything but softball on Friday. It was pure hardball, and I believe it had an impactful statement. So what I'm going to do now is I'm just going to take a little time right off the top of my cup of my head to state some questions that I would have posed if I were OFI of Mr. Seymour, and then as I salute, that will be Mr. Seymour's response. So in order to try to counterattack what I think was an incredibly effective moment in that trial, I would have posed questions like this and would have expected answers that he's going to give, because they're very obvious answers. So let's kick it off. Mr. Seymour, is it true that banks operate on a high level of leverage? Yes. Okay, and can you explain for this jury what that means, that banks are highly leveraged? Well, every company, be it a bank or otherwise, the assets will always equal the combined total of the capital, which is the business ownership interest, and debt. And in the case of banks, about 93% of the funding of their assets comes from debt. which is primarily deposits, and only 7 cents out of every dollar comes from capital. That is either owner injection or accumulated earnings. So banks operate on a premise of high leverage, far more so than other companies. So it's your statement that it may be risky, the same identical investment may be risky for a bank because of the high leverage nature of its operations versus that of a self-directed IRA. Would that be true? Yes, because by definition a self-directed IRA has a 100% capital ratio. So whereas a bank, if it invests in, say, shares of IBM, and IBM goes down 25–30%, and we've seen market meltdowns numerous times. In October 19th, 1987, it plunged 20-something% in one day, and that would literally completely wipe out your capital, because as I just mentioned, banks, a well-capitalized bank is only going to have 7% capital. So it is very important to maintain that capital ratio. You can't have it going up and down, and the regulators are not going to come in and say, well, they have no capital this exam, but hopefully they'll get it back by the next exam. It doesn't work that way. Now, as a sidebar, I'm sure that Mr. Price would have pulled another one of those, although he's not the one questioning the witness, but is it your intent to go home by Christmas? But at any rate, getting back to the line of questioning, so is it your testimony then that while an investment in IBM may be a very sound investment from an individual's standpoint, it would not be tolerated by the OFI for a state member bank a state chartered bank to make that same identical investment? Yes, that's very true. In fact, banks already know they are prohibited from making investments in common stock. It's far too risky. Notwithstanding the potential return, it can wipe out your capital. So it would be very unsafe and unsound, but bankers already know that. All right, well then, so you felt a need to send this memo out merely to provide clarification that the OFI was deeming the Stanford Investment Bank CDs to be too risky from your vantage point as a safe and sound investment. That's correct. But the same identical investment in a self-directed IRA, which if I understood your testimony previously correctly, has a 100% capital funding, may not be so unsafe and unsound. That's correct. And let me just say this, on that letter, at one point Mr. Seymour did say that the above market rates that those CDs were offering, because Mr. Price wanted to quiz him on the content of the letter. And so Mr. Seymour said, well, we're basically saying that we're deeming it to be unsafe and unsound because the market, the rates that were being offered on these CDs were far in excess of comparable CDs. And Mr. Price said, oh no, that's what you want that letter to say. But that's not in that letter, is it? I'm telling you that this was by far the most effective segment of the trial, in my opinion, for the plaintiff victims. And my statement to that is that we don't have to reduce that to writing in the letter. Bankers are intelligent. Bankers recognize regulators as being intelligent, and regulators recognize bankers as being intelligent. So there was no need to reduce it to writing that these CDs offer substantially higher yields than comparable CDs in the United States. It was known. That's going to constitute the drill down, and I wanted to make it as first part of this video because I do believe that the Phelps-Dunbar attorneys have a problem on their hands if they don't manage to attack that perception that these elderly investors were just thrown to the wolves on this while the state chartered banks were protected by the same regulatory agency. We'll see if they are able to, through subsequent expert witnesses or perhaps recalling Mr. Seymour, we will see if they opt to try to recover on that, because in my opinion, Mr. Price landed a solid blow. Now, I have no idea if it will be a knockout blow, but you know, I was very candid when I criticized, from my vantage point, his questioning technique. I will be equally candid and equally honest in saying that I believe he landed a solid punch, a solid one. Or if you want to use a baseball analogy, he swung that bat and he made contact and it went over the fences. Whether that'll end up being the whole game, we don't know. So let me just say this. The OFI did have Mr. Seymour up on the stand. They made it clear that he was under direct examination. Mr. Price then crossed, and at that point, the plaintiffs rested, meaning their case is over. And it was very easy to predict. They had even hinted that this would take place during that discussion about the expert witnesses and whether or not there would need to be a Doe-Bear hearing, that the OFI would be filing a motion for directed verdict. Now what that means is, okay, the plaintiffs have now fully put on their case, they have rested, and we deem them to not have demonstrated their case, and we believe that we should get a ruling from the bench in our favor because of the grossly inadequate proving of their case of liability on the part of the OFI. Mr. Michael Valentino was the one to make those arguments for the OFI. He had a PowerPoint presentation. I think he did an outstanding job. And just as I was candid with you about Mr. Price's landing the punch, quite frankly, I believe that the motion for directed verdict should have been granted. And I believe that Judge Johnson also had severe reservations about not granting it, because in making his ruling, what he said was, well, I guess if insufficient evidence has been presented to move this case forward, I have an obligation to go ahead and kill it here. He said, but with the record being very well reflected that an appeal could take place, I'm denying the motion. I think that was as close to an admission that the plaintiffs have not met their burden of proof. And I'm going to be perfectly blunt, I was extremely underwhelmed by the totality of the evidence that the plaintiffs put on. There was just absolutely nothing put on that could clearly demonstrate that the OFI failed to exercise any due of care that they would have to these investors. Again, these are self-directed IRAs. The OFI had no authority to go in there and try to tell these people you should or shouldn't invest in this. What the OFI did is its proper due diligence of checking to make sure all of the investors in this trust had signed paperwork that said that they are accredited investors. That is to say, they had over $1 million in net worth, net of the home, or $200,000 income if you're single, $300,000 if you're married. They did that, okay? And because of the non-discretionary nature of these IRAs, then it would only be the account holder who could have any authority to make the investment decisions on this. Now, I have had a number of folks that have told me, hey, I was not a millionaire. Well, the OFI has testified that the paperwork was there where these investors attested that they were, in fact, these accredited investors. So all I can say, if that is the case, be careful what you sign. Because just as Ms. Allen said, when you sign a tax return attesting to the fact that it's accurate, you're going to be given the credibility that, hey, okay, they signed this thing, it's accurate. Similarly, when you sign that document saying you are an accredited investor, then it's going to be accepted. It's that simple. So that's largely going to cover everything, but I'm going to take just a quick moment to glance over some notes to see if there's anything noteworthy that hasn't already been covered, and then I'll tell you where we're indicated to be going Monday at 1 o'clock when court reconvenes. I'm not going to go over everything Mr. Valentino presented when he put the PowerPoint up there, but he did make the analogy that basically this was nothing more than a safe deposit box, and they could not make the decisions in that regard. These were non-discretionary accounts in a trust, but I've already drilled that home numerous times. So their primary focus was on the risk to the trust. And also, while Mr. Seymour was up on the stand, he did indicate that when they had that infamous meeting in Fort Worth, Texas, he indicated that they being the OFI, had been told to, quote, stand down, okay? That's the reason that last report had that 2 rating. They had been told, hey, stand down. We don't want management getting tipped off to the fact we may know this is a Ponzi scheme. There are some other things, but I don't want to be duplicative, and most of this has been covered in prior features, and I try to keep them from being too long. But I will point out that Mr. Seymour said that subsequent to that June the 5th meeting, let me see, there were 3 consecutive dates where the OFI made attempts to get more solid information on Stanford International Bank. They weren't happy with what they got in all 3. There were 3 consecutive incidents. One, I think they got a letter from the CPAs down there, and they didn't give that any credibility. I wish I'd have put a marker on that so I could go right to it. But at any rate, suffice to say, they never was short of getting the actual work papers for the examination of the bank down in Antigua. They were not going to be satisfied. All I'm missing is the dates. It was 3 consecutive dates where they got 3 different instruments, and I'm not, rather than search around for it, I don't want to make this video too long. Oh, I'll put it back this way. Looks like maybe 4/9 of 08, 4/10 of 08, and then 4/11, yes, for April 9th, April 10th, and April 11th. On the 9th, they got a letter from the regulatory services in Antigua. That didn't satisfy them. On the 10th, they got a letter from the CPAs who did the audit on the bank. That didn't satisfy them. And on the 11th, they got a letter from the Stanford Holding Company, and that did not satisfy them. They wanted the work papers. Also, Mr. Seymour indicated that after that June 5th meeting in Fort Worth, that the FBI came in and served a subpoena. I believe that was late December of 08 no, actually I wrote down as October 27th of 08. The DOJ and FBI came in with a subpoena for OFI's records. Of course, that was pretty much sending the end on that. So I'm going to let that do it. The OFI began its defense first by calling Ms. Deidre Moore, and I'm not going to go into all of the detail of her testimony because they put a whole bunch of documents up and basically had her confirm that these documents were authentic. And so the court will reconvene at 1 p.m. on Monday, and I guess the issue of the 2 expert witnesses, and the reason there's such a squabble over expert witnesses is courts are not just going to slap a title of expert witness on somebody without thoroughly knowing that they have the credentials to warrant that title. And Mr. Price clearly is trying to block that. And as I said, Judge Johnson said, I'll deal with it at the point that it's called for, at the point that the OFI may call for that witness. So my guess is that's going to be confronted probably fairly early on on Monday. Well, again, we reconvene at 1 o'clock. And then after that, who knows? The trial may very well come to a conclusion and the instructions be given to the jury on Tuesday. Small chance it may be sooner, but that would be very late Monday, but look for the more likely scenario to be Tuesday. So I've tried to start this video off going straight to the heart of the matter. In my mind, the most consequential moment of the trial to date is Mr. Price's question of Mr. Seymour about these class members being thrown to the wolves. Tried to present how I think that could have been better addressed and still can be better addressed by the OFI, because I think right now there is a hole that's been dug from that line of questioning. I have to take my hat off to Mr. Price. The same way I criticized him about his questioning technique, I take my hat off to him in the posing of that question, especially the way in which he questioned it, because in my mind, I'm picturing a whole pack of wolves attacking these investors. And because the jury members are going to know next to nothing about banking regulations, it's quite possible that they're thinking in their mind that, well, gee, they're protecting the big gigantic bank, but let these little squirts get fed to the wolves. So that's why I have said that I believe the OFI attorneys need to counter that perception, because I feel certain it's probably there with the jurors. Alrighty, folks, that's a wrap for segment 5. We look forward to bringing you segment 6. And it may be short because it's only half a day tomorrow, but we look forward to bringing you segment 6 real soon. Thank you once again.